The role of the court officer is to act as the liaison between the probation department and the judge. As a court officer, we represent the probation department. We provide information to the court such as programs offered through probation and in the community, restitution, facts regarding the minor's case, social history, dates of arrest, dates of releases. We take part in discussions with the judge, the DA, and the public defender. We discuss the best interest of the minor and try to come up with a resolution that's going to best fit the minor's needs. Our role as probation officers in the courtroom is also to consider the safety of the community and what is going to benefit the victims.
My role is to make sure that the process is fair and that the rules are followed. When the deputy district attorney and the defense counsel cannot come to some resolution that they can agree on, I get involved. I try to find a resolution in the case. When there is a jurisdiction hearing, of course, it's up to me as the judge to decide if the petition is proved or not proved, which means whether the minor in fact committed the crime that he's charged with or did not. And ultimately, it's my decision to fashion an appropriate disposition to ensure that the young person stays out of trouble in the future.
The court process is comprised of a series of hearings. Detention hearing. A detention hearing is the first court appearance for youth who are currently in custody. During a detention hearing, the judge will determine if the youth should stay in custody or be released to parent. Whether in custody or out of custody, during the youth's first court appearance, they will be advised of their charges and appointed an attorney. Pretrial hearing. A pretrial hearing is where the youth attorney, the district attorney, and the judge try to come up with a resolution for the case. Jurisdiction hearing. A jurisdiction hearing is similar to an adult trial with a few exceptions. Juveniles are not entitled to a jury trial. The judge alone makes the determination as to whether the youth has or has not committed a crime. Disposition hearing. A disposition hearing is where the judge renders a decision.
When I think about a disposition, the thing that I'm thinking about is, on one hand, public safety, and on the other hand, the best interest of the minor. Almost all the kids that come to juvenile court are given a second chance through programs of diversion or probation, and it's my job to formulate terms and conditions of probation that will ensure that the young person stays out of trouble and that they're headed in the right direction.
Unlike adult court, we don't predetermine how long probation is. If the minor's doing great on probation, a probation officer could recommend terminating them after 6 months. However, let's say after they're on probation, they continue to do poorly. They're picking up new crimes, they're continuing to do poorly in school, they may be affiliating with gang members or whatnot. In cases like that, the law allows us to retain jurisdiction until the minor turns 21 years old. So even if the offense is committed, let's say when the minor is 15, if they're not doing well, we can keep them on juvenile probation until they're 21 years old. So basically what that means is it's really up to the minor to decide exactly how serious they want to take probation, and based on their performance, they could be getting off probation sooner than later.
Tips for families coming to juvenile court for the first time would include bringing documentation of school records, maybe a report card, certificates from participation in athletics or extracurricular activities would be helpful. Anything that explains your child other than the crimes that he or she may be charged with. Also helpful, maybe participation in church youth groups or other counseling services that your child has been attending. Additionally, you will speak with an attorney on that day. They will explain the process of what will happen in court. Things happen very quickly once you are in the courtroom, and it's difficult sometimes to understand what's going on. Understand that after the initial appearances, most cases do get set for a future court date. So there will be time to understand the proceeding and what's going on and discuss with an attorney future proceedings and what the plan of action will be for the young person that's charged with a crime.
For the parents, I would say that come to court. If there's a court date, it's hard. You have to work, you have other kids at home, but I would recommend making a huge effort to show up in court, to show the support for the minor, especially when the minor's in custody. Seeing a parent makes a big difference in the minor's attitude while he's in custody. Also, by the parent showing up in court, they're able to get the information that they wouldn't otherwise. A lot of times the minors tend to interpret things different, so when a parent is there, the parent might be able to explain what just happened better to the minor, since court does go so fast, and a lot of times the minors are listening but they're not understanding. And I think that's a huge deal for the parent to actually show up in court and be there and show the support for the minor.
Well, what I want parents to know before they come to juvenile court is that the judges of the juvenile court are parents too. We know that making mistakes is part of growing up. The juvenile court is not here to punish kids. The purpose of the juvenile court is to provide the kids with the treatment and guidance that they need to stay out of trouble in the future. Almost all the kids who come to juvenile court are given a second chance through programs of diversion and probation. Most of the kids will complete those programs without any trouble. They won't get in trouble again, and they won't need to come back to court. Those kids that do get in trouble again, we will continue to work with them to steer them in a positive direction.
My son is doing better. We are dealing with some of the problems still, but it takes time. And as long as he follows the probation rules and so forth, I think he's going to be just fine. The system is working now for him and for us as well as parents, and the outcome looks promising now, where just a year ago, if you would have asked me, I would have told you I don't know what was going to happen. But it looks promising now, and we have the tools, the resources, and the folks involved in my son's life to get him straightened up and help him with any issues that he has. And when he does become an adult, you know, hopefully he'll look back at this time as a learning experience instead of a disciplinary issue, and learn from his mistakes and be able to help his own children when he has them.